Hi there, you're with BQ Prime, and this is the fine print. Via an interim order yesterday, market regulator SEBI barred SL Group Chairman Subhash Chandra and Zee Entertainment CEO Punit Goenka from holding any board positions or in a listed company or its subsidiaries. Now, via this interim order, the regulator has said that both Chandra and Goenka abused as director or KMP, key managerial person of Z, to siphon funds for their own benefit. Now, besides the SEBI order itself, there is a parallel Z and Sony merger underway before the NCLT. I'm joined here by Murali Neelakantan, independent corporate lawyer, to understand how this SEBI order and one passed by the regulator in April 25 against one of SL Group's listed entity are going to impact, if at all, the merger proceedings before the Company Law Tribunal. Murli, thank you for coming here and joining us with your thoughts on how all of this is likely to play out before different regulators and different courts, regulator being SEBI and maybe at NSE at BSE, and courts being the Securities Appellate Tribunal and the NCLT. Before I come to you to sort of understand the implications of this SEBI order, I want to take my viewers through what is it that the regulator has said. Now, SEBI has passed an interim order, like I said, against promoters Subhash Chandra and Punit Goenka, and it has found both of them in violation of the listing regulations. The interim order says that Chandra had signed a letter of comfort on Zee's behalf, and the board of Zee was not. Had no knowledge of this letter of comfort. And what is it this letter of comfort did? It essentially was issued against obligations of associated entities which are controlled by the promoters, namely Chandra and Goenka. And the obligations of associate entities were met by appropriating Zee's fixed deposits worth 200 crore. When Zee, in its responses, told SEBI that those associated entities had paid back Zee, SEBI went deeper and looked into the books of Zee to only figure that the transactions were bogus entries, and in fact, those funds which Zee had claimed has come back to it originated from the company itself. Now, in all of this, SEBI has noted that the funds that were siphoned off ultimately benefited the promoter family. SEBI has also referred to its April 25th order against Shirpur Gold Refinery, which is again a listed company owned by Subhash Chandra and his family members. There too, funds worth 400 crores were diverted for the benefit of promoters, SEBI had found in April. Now, besides this order impacting the impending or the proposed merger with Sony, Murli, we'll come to that in just a bit. But just by itself, this interim order, which is now, and as we understand from lawyers involved in the matter, has been appealed by Punit Goenka before SAT on grounds of principles of natural justice. Murli, what do you make of the interim order itself?
The interim order is quite well reasoned. So there seems to be a good prima facie case. Now, whether that is enough, whether there are facts they did not consider, whether there's a good rationale for all these transactions and which all happened within about 48 hours. So it's going to be quite difficult, I would think, for the company and for the directors to be able to explain what these series of transactions were totaling thousands of crores and how it is that these transactions were commercially necessary. Many of these companies are just paper companies. They have no employees, they have no assets, they have nothing. So I would find it quite difficult in this circumstance to be able to say that, hey, there is no prima facie case. Now, having found a prima facie case, does this order stand? Is it necessary for SEBI to take that into measure? And it seems to be that there is a good reason for that interim order to be passed without listening to what the arguments of the company and its directors are. And therefore, it seems that there is a good rationale in this case that they were in charge of the company. They could stop this company from providing the information, stop the investigation, come in the way of it. So there's a good reason to prevent them from being in charge of this company while this investigation proceeds. So I would think it's a good order. Whether the appeal succeeds, whether SAT says no principles of natural justice need to be followed before an order is passed in every instance or not, I don't know. It's very hard to predict these days.
But would you think that an order of this nature, Murli, before the regulator makes its interim findings, should have given the sort of Goenka and Chandra an opportunity to be heard? Because look, on the face of it, like you mentioned, the order is quite exhaustive and thorough. SEBI has diagrammatically shown the movement of funds, how it originated from Z, went through maybe as many as 13 entities before it came back to Z, right? So SEBI has detailed, those transactions with each of the 7 associated entities. Do you think that the process itself could have, maybe taken another month to give Chandra and Goenka the opportunity, and maybe then SEBI would have proceeded on a more surer ground when this was inevitably going to be appealed in SAT?
I think the regulator has a challenge. One is, if you know all of this and you allow the person who you accuse of doing all of this to see all of this material, and the person is still in the company and able to manufacture or create evidence to cover his tracks or to make up stories, versus saying, no, we'll give you all of this material, you think about it, we'll give you a month to respond, you come back with paperwork, then we'll hear you, then it'll go up in appeal. That is the challenge. Do you go after them and say, we found good evidence, we don't want you to tamper with any of it, we don't want you to be anywhere in control of those companies? Or do we say we'll follow principles of natural justice with the risk that all this evidence may not be as strong as it looks now, and there is a chance that paperwork could be fabricated? It's a very difficult one. But prima facie, it looks like they have a good case. The interim order is a good interim order. And without the interim order, it may be possible to argue that the investigation itself may not come to anything.
Okay. So we'll see what happens on Thursday, which is when Goenka's appeal is listed before the Securities Appellate Tribunal. But what everyone seems to be interested, Murali, at this point is, how are these 2 orders, one against Shirpur Gold Refinery and now against Chandra and Goenka, is going to impact the proposed merger between Zee and Sony's India unit? Now, again, to just give some background to our viewers, the last development on that case was that the National Company Law Tribunal, before which the scheme is pending for approval, had asked the stock exchanges that in light of the April 25th order, the exchanges should reconsider their approval to the merger. And they were also asked to look at the non-compete portion, which was going to some of the Mauritius entities. That order of the National Company Law Tribunal was again appealed by Goenka before the Appellate Tribunal, and a stay for a stay. But the Appellate Tribunal just said that, look, the principles of natural justice were violated. You, the NCLT, should have heard all the parties before you directed the exchanges to reconsider their approval. And so now everything is back at the Company Law Tribunal. Parallelly, there are also several sort of creditors which are before the NCLT opposing the Zee-Sony merger on various grounds, those being JC Flowers, Axis Finance, IDBI, saying that, look, some of the money that was given to SL Group entities, there was, agreements that were signed, or those, assurances given that that money will come to them, and it has not. So there is a whole messy situation there. Murali, how does all of this fit with what's going to happen on the merger front?
As you said, it is quite messy. So, and a lot of this is unprecedented. I don't think the NCLTs ever had to deal with something like this. They've had to deal with situations where creditors are against something, for example. So you have a majority of creditors against something. They haven't had a situation that I can recall where The shareholders have said yes. The majority of the shareholders have said yes. The majority of the creditors have said yes. And there is the minority, which is institutions, again, unusually, who are alleging that there is a lot of financial fraud that's happened and they're owed money, not just from this company, but through this company from other companies. Uh, so it is quite messy. And I would think it would take a very brave bench in the NCLT to say we're going to ignore all of this and just stick by the rule that the majority has approved, and therefore we will not investigate any of this, or we will not allow anyone to talk about anything else. I think that would be a very brave decision. I don't think an NCLT bench would be so brave.
Okay, Murali, let me just take a sort of macro view of the situation. At the heart of it is company law, right, which has certain ingredients for NCLT to look at to say whether a merger is kosher or not, can it go ahead or not. One of it involves, statutory approvals, creditor and shareholder approval, and of course, there is broad language to say that if NCLT finds that there is something amiss, it can, in the interest to meet the ends of justice or some such language, pass directions, right? So there are several outcomes possible, and in all of this, as proceedings go on before SAT, the exchanges at NCLT, and from all these forums to various appellate forums, the big question is: will Sony be a patient partner? So the market really wants to know that what is going to be the end result in terms of the mergers. One is that the scheme passes on an as-is basis, like which you've mentioned, is going to be very difficult for the bench to ignore statutory or SEBI orders, right? The second sort of option is that the merger or the scheme of arrangement gets altered in some fashion to reflect the gravity of what the regulator has found. And that amended scheme then again has to be put before shareholders and creditors. Exactly. And the third is that NCLT says, no, we're not approving this merger at all because several creditors are getting shortchanged. They may be in minority, but they're getting shortchanged in the process. I'm asking you to crystal ball gaze a little bit here, but what do you think is the likely outcome of all of these legal disputes?
So I would think that time is going to be a big factor. Given the complexity of the proceedings now, it's stuck in 3 different places, and each of those gets unstuck and then go through the appeal process again. So time is going to be a factor here. Now, if time is a factor, then it's up to Sony if they want to continue with this or not. And they will have a challenge because their shareholders are going to be asking their board what diligence they did. Did they know all of this? If they didn't know all of this, then now that they know it, do they still recommend that the merger continues? And with the changed knowledge of facts that we have, is it going to be a different scheme that they will approve rather than the scheme that is before the NCLT? So there's going to be a lot of pressure on the Sony board, and Sony shareholders should be really worried. They should understand that they may not have got the deal that they thought they were sold by the board and recommended to them. So I would think that there is going to be a lot of pressure there. And that would mean that as time passes, this gets muddier. There might be a little less interest from the Sony side of the deal to actually close this in the form that it is at the moment.
And do you believe so? One of the sort of aspects of the merger or conditions of the merger is that in the merged entity, Punit Goenka is going to continue to lead it. Could there be a case, and I'm sure the creditors who are agitating against the merger as we speak are going to bring this new fresh SEBI order before the NCLT and to its notice and point to it and say that, hey, look, there's another evidence why this merger shouldn't, sail through. Can we then see an amended scheme to say that, look, Goenka will not be sort of part of the merged entity or on the board of the merged entity or in a managerial position? And I mean, I'm not sure again how palatable will that be to the existing promoters of Zee. Is that a likely outcome that will sort of end in a fatal outcome for this merger process?
I think there's issues with just complying with the SEBI order. So let's assume that the SEBI order in appeal is upheld and said, no, the interim order is good. So that's one scenario for you where SEBI order is upheld in the two appeals, at least that they have, and goes all to the Supreme Court, let's say, and everybody says, no, the interim order continues. Then we have a challenge that the scheme as presented to the NCLT is now having to be changed. That's one scenario. The second scenario is the interim order is stayed or quashed, like the other order for the stock exchanges got quashed. This one got quashed, and they should start afresh. And that could take months, maybe even years to resolve. So if you have to resolve that issue of whether or not the two of them should be investigated, should be heard, appeals happen, again, it's going to be time. So irrespective of which way you think of what the issue is, the challenge is going to be time. And over time, what will be the pressure on Sony to close this deal in whatever form? And definitely not in this form. So I see that as the play. It will almost certainly, in my view, not be the form that's been presented to the NCLT. What is the other form, or will they just call it off? Those are the two alternatives before Sony.
Yeah. Murali, I'm going to take a slightly more simplistic view to this situation and say that, look, the ingredients, like I mentioned in company law, that require that a scheme goes through, the key is shareholder and creditor approval. And if that has come through, can any tribunal or bench say that, look, if the shareholders and the creditors are okay with it, the scheme should pass muster?
It's true. But the challenge now is going to be for the shareholders, the majority shareholders, the creditors, and the board to answer the question, did they know all this? Because fraud, which is what's the allegation here, vitiates everything. So the group of stakeholders challenging the scheme will contend that there has been a massive fraud. We found one, there may be more. The whole process of reporting to the board is flawed. And that is the allegation here, that related party transactions have not been disclosed to the board. Forget approved, not even been disclosed to the board. So directors don't know it. Haven't been reported to the exchanges. So there is a failure of disclosure, there's a failure of reporting, there's a failure of approvals. So is this a systemic problem within Zee and within the Zee group? Those are the questions that are going to be asked by the stakeholders before the NCLT. Now, given this background, should the scheme be approved? Because the board didn't know all of these details when it approved the scheme. The shareholders didn't know all these details before they approved the scheme. And should actually an audit be done, a forensic audit be done, to say the actual accounts are the following and not what has been presented to the board, to the shareholders, and to the exchanges. Now, that I think would be a compelling argument. It would be very difficult for the NCLT to say, no, we don't really care. Whatever fraud may have happened, whatever the disclosures may have been wrong.
All right. We've lost Murali's connection for now, but I believe the essence of the
that's all irrelevant.
sort of
once a recommendation is made, once the holders vote, we won't go behind all that to understand whether these recommendations or actions by the board, the shareholders, and the creditors are vitiated by failure to disclose, fraud, any of these things. I think that'd be very brave for any NCLT bench to say, oh, we're going to ignore all of this. It's a matter of once you've decided, it doesn't matter what the basis of the decision is, it is approved. I think that would be very difficult.
Essentially, what Murali is saying is that in its current shape and form, of course, the scheme will be difficult for the NCLT to pass because several new facts have come to light, which might require the NCLT to say that, hey, look, when the shareholders approved the merger, they were not aware of those facts. So a shareholder, a creditor, a statutory approval and exchange approval is required to be taken again. In one line, the merger is not going through anytime soon. Now that there are several legal disputes in various forums before, from SEBI to SAT to NCLT, and of course, all of this will get appealed by various parties. Thank you for joining us here on the Fine Print, and apologies for the last minute technical snag. Stay tuned to BQ Prime as we stay on top of the story. The next sort of milestone being the Thursday hearing before the Securities Appellate Tribunal on Goenka's appeal. Thank you for joining us.